of what nobody says about none of that. I'm going to be calling until my court date. They're not going to do shit. At the end of the day, they can't do shit.
If he thinks we can't do something, you're going to look at this judge and think I can't do something, young man. You're going to learn a big...
Court calls the case of the people versus Marquesi Hankey.
Your Honor.
Good afternoon, Your Honor. Attorney Kevin Hassan, P7.
All right, it's your motion.
I did file a motion to take the previous PTC hearing. My client's bond vote from privileges from the jail suspended due to allegations that he cut off his tether and contacted the complainant. Following that particular bond hearing, I instructed my client to not contact the complainant witness, period, in the jail. I also instructed my client that if allowed to be back on bond, we would ask the court to hopefully to reinstate his original bond tether. I would note that he has no prior criminal, well, no prior adult felony conviction whatsoever. Following the submission of my motion, I did read the people's response, which I guess there's been allegations that my client had contacted the complainant subsequently. Now, I just found out today some transcripts. Obviously, people address this. Some of the language that was used during conversations, I don't have phone conversations myself, but I will admit, Judge, that it seems that my client had contacted the complainant even after his bond. And so I say this, Judge, again, I know it seems like my client is kind of throwing up his middle finger to the court.
Oh, yeah. He is.
But Judge, I just would state that this young man, I think he understands now that the court orders are serious, that the court orders him to do something, it means it. So Judge, I'm just asking, I guess, for some leniency to trust that Mr. Hankey will comply. He had a $75,000 cashier bond that he was able to post to a bondsman. The only thing I can ensure that if the court were to give him a second chance, he would not violate his bond, even if the bond is a house arrest with strict conditions. So Judge, I am asking the court to reinstate his bond, and if the court is unwilling to do so, I would at least ask that his phone privileges be allowed back on to at least contact family. Does he's never had any contact with his family, his children? He hasn't been able to contact his dad, caretaker for. And so at the very least, the restriction on his phone privileges to contact family.
All right. Well, before I hear from the people, counsel, let me just say, you came in here the first time, and well, let me start with this. Where's our tether?
From my understanding, Judge, I thought community corrections still had it. I thought they had become.
He cut the tether off. We haven't seen it.
Okay.
And I know you made the representation to the court, but I know you wouldn't have personally known that. I'm sure that came from your client or something along those lines. We don't have the tether back.
Okay.
Then, you know, and I get you're making the representation saying your client's going to follow what the court says, but I don't know if anything can be as shocking as walking into a court free. Your bond gets revoked. You get put in jail because of something that you've done, and then you still go about violating the court's order.
I'll be honest with you, counsel. I mean, I get what you're saying. I don't have a problem giving people chances. I just don't know that this is the one to give a chance to. Because he just hasn't done anything the court's asked him to do. Ms. Senda.
Your Honor, I will rely mostly on a motion. However, in listening to his jail calls, he has 45 total calls to one number after his privileges were revoked with different pins he's using. Then to the other number, we have 23 calls that were completed since his privileges were revoked with different pins. And in one of these calls as recently as Monday, there were a few memorable quotes that I heard in the calls, such as, "There's not shit in this world that's going to stop me from talking to you, man. Nothing in this world stopping me from you. I don't hook up what nobody says about none of that. I'm going to be calling until my court date. They're not going to do shit. At the end of the day, they can't do shit. I'm going to talk to you till I can't talk to you no more. I'll be home. I'm not worried, man. I know I told you this is about to be my last call, but I'm not stopping shit. I'm not stopping nothing." And then, why stop now if they already know? So I have extreme concerns that he cannot follow court orders, considering he cut off his tether, continued flagrantly calling the victim on other pins, both numbers, acknowledging in some of the calls that he should not be contacting her, and continue to contact her. He just cannot abide by any of the court orders that are set before him. So I have great concerns, and especially given the violent nature of this case as well.
Anything else, counsel?
I mean, counsel, does your client want me to just request to the jail that they put him in solitary so that he has no contact with anyone, can't use their PIN number? If he thinks we can't do something, and if particularly you're going to look at this judge and think I can't do something, young man, you're going to learn a big lesson.
So I definitely don't want that. My client.
Well, he needs to, and I don't mean to interrupt you, counsel, but he needs to understand. You can say all that stuff. You are not that big, not that bad. Now, if you want to play with me, this is the kids say, mess around and find out. I guess that's not the quote, but it's close, but I did pretty good. I said it okay, right now. All right.
So just, if I may, just briefly, my client would like to.
Go ahead.
I want to apologize. I don't think I'm being bad at all. He is pregnant by my child. I can't say that I'm not in here for nothing. You obviously think I am. Yeah. I just want to apologize. Like I said, I'm not being bad. I don't want to be here at all. I really don't. Truly. Again, please show mercy. Please. That's all that matters.
I have no problem showing mercy to those that deserve it and have earned it. You have not. Motion for bond reduction or any change is denied. His bond will continue as revoked.
Thank you, Judge. And for the record, this is also, from my understanding, the PCC.
Yes, sir. Is all discovery complete?
And I would ask if possible, if possible.
People have their witnesses available on the first.
We'll do our best, Your Honor.
Preliminary examination in person will be set April 1st, 2025, 9 a.m. in person before Judge Perry.
And Your Honor, I did want to make a court aware. I did contact the jail yesterday, and they have blocked both of victims' new numbers and old numbers, so there should not be any more
calls coming through. All right. Thank you.
Thank you very much, Judge.
Thank you, Your Honor.
And that is the final word from the court. The request for bond reduction or any change in the existing conditions is denied, and the bond remains revoked. Looking at the hearing as a whole, the defense asked for leniency based on the defendant's lack of prior felony convictions, his willingness to accept strict conditions, and his desire to regain contact with family. But the prosecution presented repeated evidence of alleged violations, including calls made after phone privileges were revoked, continued contact despite restrictions, and the missing tether after it had been ordered as part of his release conditions. The judge made it clear that mercy is something the court can give to someone who has earned it. But in this hearing, the judge concluded that this defendant had not. A preliminary examination was then scheduled, while the jail was instructed to block additional numbers associated with the prohibited calls. What do you think? Was the judge right to keep the bond revoked, or should the defendant have received another chance? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.